Welcome to the launch of the Cambridge Companion to the Philosophy of Law. Cambridge Companions are authoritative guides written by leading experts offering lively introductions to important topics. And this new volume on the philosophy of law is a guide that we need, especially at this time. It may seem like the world is falling apart. We have pandemics, both viral and racist, deepening inequalities, failing political institutions, a climate catastrophe, and misinformation swirling around us. How do we make sense of what is happening? How do we develop ethical and sustainable solutions, including through the creation and application of law? What does a more just world look like at the end of this? And how can the law help achieve well-being in the broadest sense? As John Tasioulas notes in his introduction to the volume, the contributors were asked to identify what they judged to be the key questions for us today and the most compelling lines of approach to those questions. It is a book for this moment. And even though we are meeting virtually today, I hope that we can make a genuine connection and share ideas and learn from those who've been thinking deeply about these issues. So this will be a two-part event. First, we're going to have the launch of the Cambridge Companion, and then we're going to have a very special panel on the teaching of jurisprudence chaired by my colleague, Dr. Christoph Kletzer. Philosophy is a strength at King's. The editor, John, and 5 of the contributors to the Cambridge Companion are all academics at King's. But the volume also shows what an international subject this is, with contributors from a range of countries, and we're very lucky to have some of them joining from overseas today. So for the launch, this first part of our event, we're going to start with an introduction from the editor, Professor John Tasioulas, who is also the director of the Yeo Tiong Lei Centre for Politics, Philosophy and Law. We will then have comments from contributors of about 5 minutes each. And I'm going to now in advance introduce our contributors briefly. They are some of the most exciting thinkers and writers in this field. We will hear from Baroness Honora O'Neill of Cambridge, Professor Daniel Markovits of Yale, Professor Sophia Moreau of Toronto, and then 3 of my colleagues from King's, Dr. John Stanton-Ive, Professor Massimo Renzo, and Professor Guglielmo Verderame. To those watching, please do write your questions in the Q&A box. We've reserved some time for discussion and we look forward to interacting with you. And it's now my enormous pleasure to give the floor to the editor of this magnificent book, John Tasioulas.
Well, thank you so much, Philippa, and thank you everyone attending this launch. And most importantly, thank you to the other 22 contributors for their excellent chapters and also for their patience. Oscar Wilde once said that only shallow people don't judge by appearances. So I'm going to begin with the book's cover. It's a reproduction of The Three Judges, a work of 1936 or thereabouts by the French artist Georges Rouault. He was associated with the Fauvist and Expressionist schools, and he was also, coincidentally, a close friend of the great natural law theorist Jacques Maritain. The painting is from a series of works that take as their subjects courts, clowns, and prostitutes. All 3 involve categories of people occupying the margins of society in some way. In the case of the judges, it's the marginal position of someone who stands in judgment over others. As Rouault observed about the 3 judges, quote, "If I have made judges such lamentable figures, it is doubtless because I betrayed the anguish which I feel at the sight of a human being who has to pass judgment on other men. The judges themselves I could not condemn." The painting conveys the idea that the law may be essential to human life, but that the values and aspirations associated with it often place intolerable burdens on fallible human beings who inevitably fall short. Much of the Cambridge Companion is concerned with the ethical values that justify law and give it purpose and direction. This can give the mistaken impression that legal philosophy sugarcoats the grim reality of law. The cover serves as a reminder that the fact that an institution is rooted in ethical values is no guarantee of its success in achieving them. And this reminder is, I hope and believe, echoed in various chapters in this volume. Now, in my introduction to the companion, I talk about three overarching themes that are discernible in contemporary legal philosophy and which leave a strong mark on this book. The first is the downgrading of the familiar clash between legal positivist and natural law theories that has taken place in recent decades, and associated with that, the move away from developing general theories of the nature of law. From the time I started teaching legal philosophy way back in 1992 at Glasgow University, I've always had misgivings about the tendency to make the natural law versus legal positivism opposition central to the subject, the eternally recurring World Cup final of legal philosophy in Tony Honoré's striking image. Although this setup does indeed inject some drama into proceedings, it's misleading for two reasons. First, because it grossly oversimplifies the rich diversity of views within each camp, and also the profound commonalities that exist between thinkers assigned to different camps. But second, even as a pedagogic device, I think it panders to an idea that as teachers of legal philosophy, we should be straining every sinew to resist, which is that the subject is essentially a zero-sum struggle between two totalizing ideologies, and that ultimately everything comes down to some kind of willed allegiance to one camp or the other. This approach deprives students of the most liberating of all revelations, which is that the issues that divide legal philosophers are ultimately matters for reasoned debate, rather than uncritical tribal partisanship. So in the introduction, I stress three things. First, that debate between natural lawyers and legal positivists has generally bundled together many different issues. Second, that nowadays we tend to regard the key issue dividing the two schools as one about the role of moral judgment in the identification of law. And third, that this last issue is one of a large number of questions that legal philosophy must address, and by no means the most important such issue. So if the book helps dispel the myth that the golden thread of legal philosophy consists in the fault line between positivist and natural law theories, it will be doing a valuable service. Now, there are two other trends I identify of a more positive nature. The first is the rise of concern with the values and principles relevant to the ethical evaluation of law and legal systems. In the post-war period, engagement with such issues was inhibited by a widely held subjectivism about value. If values are subjective, then inquiries about the values that properly guide and constrain the law fall beyond the scope of objectivity. But this value skepticism lost its status as the default position among philosophers since the 1980s. Meanwhile, works such as Rawls's A Theory of Justice reinvigorated normative political philosophy. Now, of course, there is a discussion of normative principles in Hart's The Concept of Law, but even in the chapter on justice and morality, the notion of rights, for example, barely surfaces. Today, rights have become central to normative debate about law, both as a general framework for the moral evaluation of law, but also as a way of picking out the defining point of discrete areas of law in terms of the supposed centrality of certain types of rights within them. Indeed, far from being ignored now, moral rights tend to overstep their proper bounds. This leads us to forget that they have to operate alongside other concepts, for example, legitimacy and the rule of law, and that our ability to realize rights depends on securing non-rights related principles, such as norms of civility and public service, a point powerfully made in the chapter by Honora O'Neill. Now, even among those who take moral values seriously, there is a common tendency to shoehorn a comprehensive political ideology into a single value concept. The most conspicuous example of that these days is human rights, but similar deformations afflict concepts such as the rule of law or legitimacy. The careful investigations of distinct value concepts in part 2 of this book are a corrective to this unedifying all-in-one Russian doll approach to our repertoire of ethical concepts. They help shore up the idea that the ethical evaluation of law needs to draw on a plurality of distinct value concepts. The third and final theme I wanted to mention is perhaps the most exciting of all, and that is the rise in recent decades of what might be called special legal philosophy, the philosophy of specific areas of law, such as tort, contract, and international law, or specific legal concepts, such as responsibility and causation. Half of the book's 20 chapters belong to this category. Special theory has waxed even as general theory has waned. Now, of course, Hart was a pioneer here too, with his monumental study of causation and his influential writings on the philosophy of criminal law. Indeed, for many years, the philosophy of criminal law set the gold standard for what special legal philosophy could be. But perhaps the most exciting development in recent legal philosophy has been the renaissance of the philosophy of private law. And struggling along some distance behind, we also have the philosophy of international law emerging to challenge the stubborn persistence of postmodernist approaches in that area. A key theme here is that of whether there is some master value that provides the point and justification of a given domain of law, or if a pluralistic approach is adopted, how the salient values are to be coherently ordered in their relations to each other so as to avoid the suspicion of arbitrariness. This latter theme, the theme of coherence in plurality, runs through many of the chapters in this volume, including the sparkling chapter on tort law by the late John Gardner. John offers a pluralist view of tort law that seeks to overcome the familiar standoff between economic approaches, which see it as a mechanism for dealing efficiently with allocation problems, and moral approaches, which focus on its identification and response to certain wrongful acts. Among many other things, John's chapter is a sad reminder of what a brilliant and generous colleague we lost with his tragically premature death a year and 2 days ago. Because of this, and because he was a loyal and warm-hearted friend to me and other contributors to this volume, I was delighted that his widow, Jenny Gardner, permitted me to dedicate this book to his memory. So in celebrating the publication of this book, I feel we're also celebrating John's extraordinary contribution to our discipline and, for many of us, to the quality of our lives. Thank you.
Thank you, John. You've really drawn out the three themes that distinguish this book as a guide to the philosophy of law, and I think with a reassuring message of plurality and inclusion, the putting away of pointless battles. So now we're going to hear from our 6 commentators and contributors, and I give the floor first to Honora.
Thank you very much. When I agreed to contribute to this companion, I thought I wasn't even marginally qualified to do so. I was not a lawyer, not even a philosopher of law, and most of my writing was in political philosophy and in ethics. But to my pleasure and surprise, I ended up exploring a line of thought that's highly congruent with John Tasioulas' own contribution, and this, one has to say, despite the fact that his philosophical inspiration is Aristotelian, while mine's Kantian. I wasn't well placed to comment specifically on ways in which legislation and judicialization have taken the discussion of international human rights law further away from the basic principles of human rights, which, by the way, I too see as requiring justification that is not merely positive. But I was very interested in the implications of treating rights as central to discussions of justice, which I think are very closely linked to ambitions to incorporate human rights standards more and more fully into international human rights law. My central question then became, what did we lose as a result of the rise of human rights in 20th century discussions of ethical and political questions? And of course, we haven't left that yet. And that, by the way, is why my contribution contains, at least for me, rather a lot of historic and literary examples of the eclipse of duty that was precipitated by its overemphasis during World War I. Human rights, I think, Particularly the extensively institutionalized versions submerge other important ethical concerns that we can't do without. Focus on rights can replace the ancient and fundamental question, what ought we do, with the narrower question, what ought we get? The classical agent's question is replaced by the claimant's question. Duties are not, of course, thereby wiped off the broader ethical map, since there can be no rights unless there are counterpart duties that are allocated to competent parties. But the only duties that remain within focus are duties to respect others' human rights. Other duties become invisible. They include, among others, perfect duties, that is to say, non-optional duties that lack counterpart rights. Examples would be honesty or civility. Imperfect duties, that is, optional duties. You can choose to exercise them on a given occasion or not. For example, generosity or kindness. And all those duties that do not have defined claimants. Among them, of course, duties to future generations, where for Parfitian reasons we cannot individuate the claimants. Does this matter for an account of justice? I believe that it does. Judgment isn't simply a matter of applying rules. It's also the way we deal with the indeterminacy of rules and the more flexible specification of many of the traditional wider duties offers guidance and support that is lost by a relentless focus on rights and their institutionalization. The interpretation of human rights is not, and I would contend cannot be, algorithmic, and trying to do without a broader account of duties and a practical judgment damages human rights themselves. My conclusion, therefore, is not hostile to human rights. Human rights principles matter hugely, but they are not all that matters, and they are supported and not undermined by retaining a broader ethical framework. Thank you very much.
Thank you, Honora. We'll now move to our next commentator, and I do encourage those who are watching, our audience, to start asking questions in the Q&A box, because we look forward to our discussion. And I now give the floor to Daniel.
Hello, thank you, Philippa, for that. Thank you, John, for including me. It's an enormous pleasure to be here. I thought what I would devote my 5 minutes to is some brief remarks about method and then something a little bit about substance. Methodologically, I'm very much interested in the thought that special jurisprudence, so the philosophical study of particular departments of law, should be a hermeneutic exercise. So the idea is not to bring to bear principles of justice or morality or practical reason that come from outside the law to recommend what one or another legal department should look like, but rather to try to identify the normative principles that regulate imminently a department of law, to interpret it, to show the sorts of relations that this department of law establishes among those who engage it, and then to connect the department of law so understood to the broader legal and political framework within which it sits. So contract is a natural place to apply such a method. And just to illustrate how this might go, the two distinguishing features of contractual obligation in our legal order are, first, that contract obligations are strict liability rather than fault-based. That is to say, a promisor might have taken all reasonable care in making her promise, in fixing its terms, and in attempting to perform it. And yet, if she falls short, in spite of having behaved reasonably all along the way, taking due care for the interests of all whom she encounters, she nevertheless remains obligated to perform and is in breach of her contractual duty. So this distinguishes contracts from torts, for example. Second of all, contract is distinctive in that its obligations are forward-looking rather than backward-looking. The contractual promisor has an obligation not to make good losses caused by her contracting behavior, but rather to vindicate the interests that her counterparty has in performance. That is to say, a contract creates an entitlement in this way out of nothing, an entitlement to prospective advantage rather than to a restoration of the status quo ante. That again distinguishes contract from tort, and indeed from property, from criminal law, from lots of other departments of law. So contract is distinctively strict liability and distinctively includes forward-looking obligations. And that raises the question, what must contract be like in order to sustain those two unusual features? And the chapter that I contributed to this, I think, as John says, excellent and far-ranging volume, argues that the way to make those features of contract intelligible are to understand contract not as an allocative practice, but as an integrative practice. That is to say, not as a legal regime that has to do with allocating harms or allocating reliance or allocating investments of one sort or another, but rather as establishing a special bond between the parties to contracts, in which each party recognizes the other as holding a peculiar kind of authority over its forward-looking behavior, and that the recognized authority that the parties to contracts grant each other establishes a relationship between them which has an intrinsic value. It's a kind of relationship of recognition and respect. And part of the theory of contract on this understanding is to elaborate the nature of that relationship, to ground it in broader or deeper philosophical values. And then the last part of the theory is to explain how that relationship, the collaborative relationship that contracts establish, fits into our broader moral and political universe. And here, and I'll just conclude with this thought, contract is also distinctive in another way. It's a constitutive feature of our contract law that the party that would do better without the contract does better within it. That is to say, contract law does not require setting the world to rights before contractual obligation can get going. Instead, differences in bargaining power, including morally undeserved differences in bargaining power, are allowed to affect the terms of trade of an individual contract. And the contract becomes obligatory, even in spite of those antecedently unjustified differences. So if you want to take a very concrete example, imagine a rich professional who hires a childminder to care for his children while he is out at work. Now, as anyone who has children and a high-paying and demanding job knows, such a person is willing to pay almost any sum that they can afford in order to get high-quality childcare to enable them to practice their profession. Nevertheless, the wage that is actually paid is determined by a market in which childminders are in oversupply, are not tremendously highly paid. And so the balance of advantage of that contract dramatically favors the employer. That is to say, the difference between the most that the employer would be willing to pay and the wage that's actually paid is much, much bigger than the difference between the least that the childminder would be willing to accept and the wage that's actually paid. Nevertheless, whatever we may think of as a matter of distributive justice, the injustices in that background state of affairs, the contract of employment creates genuine legal obligations, including in the childminder. And I believe most parties to such contracts would feel themselves to be morally obligated also in light of their exchange of promises, which is to say, once again, that contract does not require setting the world to rights before its peculiar form of obligation can get going. And that is why contract plays such a central role in bourgeois, peculiarly bourgeois, forms of social and economic life. It is the structuring idea of market exchange. And now one can see why, from a radical perspective, the notion of the contracting agent is precisely the kind of notion of the formally equal agent in front of law, stripped of class associations, that radicals from Pashukanis onward have attributed to bourgeois legal orders as a form of critique, while at the same time, from a liberal perspective, the idea of the free agent recognizing others on terms of formal reciprocity of obligation and recognition retains a normative appeal, which is just to say that the hermeneutic method that I began with in thinking about special subjects in jurisprudence can have both a celebratory and a critical edge, depending on what one does with the norms and ideals that one finds immanent in the legal practices that one engages. Thanks once again. Pleasure to be here, and I look forward to listening.
Thank you so much, Daniel. I now turn to Sophia in Toronto.
Thank you very much, Philippa. Thank you so much, John. I'm very grateful that you chose to include a chapter on equality and discrimination in the volume. As many of you know, for quite a few years, there have been very rich discussions within political philosophy about the nature of distributive equality, and more recently questions about relational egalitarianism, about what it is to relate to each other as equals. But interestingly and somewhat oddly, discussions specifically about discrimination, about what makes it wrong, about whether all forms of discrimination are wrong in certain circumstances, or whether perhaps some amount to what we might call mere misfortunes rather than wrongs or injustices. These questions for a long time have been treated as a kind of part of a kind of niche area, a very specialized area that is separate for some reason from broader questions about why we ought to value equality and what it means to live together as equals. So I'm particularly grateful to John for thinking that these are not just marginalized questions, and I take it that recent political events in all of our countries have made it clear that it's more important than ever now for philosophers to start wrestling with the philosophical dimensions of these questions. And that's partly what I try and do in this chapter. As I try and show at the start of the chapter that the ways in which our conceptions of discrimination have expanded over the past 20 to 25 years. It used to be the case that discrimination was thought to be wrongful only in those cases in which it was either intentional or manifested a certain kind of objectionable prejudicial attitude. And so although there were disagreements between philosophers, this was in the 1990s, mostly in early 2000s, there were disagreements about how we should understand the problematic kind of attitude that made discrimination wrong when it was wrong. Really, those were quite specialized, rather narrow disagreements, and I don't think anyone had any difficulty with the very general idea that discrimination is wrongful insofar as it involves an objectionable attitude of this sort. And so I think when we thought of discrimination in this narrower way, it seemed in a sense less philosophically rich and less philosophically pressing, precisely because there isn't much that's surprising about the claim that it's wrong to exclude a certain person or group from certain benefits out of prejudice or hatred or some such attitude. But over the years, as I mentioned, we've seen our conception of discrimination, both in sociology and psychology and also in the law, expand to include, for instance, acts of exclusion done out of what we call unconscious bias. So cases where there is no explicit prejudice, no intent to exclude. We've seen our conception of discrimination expand to include policies that disproportionately disadvantage a certain group relative to other groups in ways that were not intended and often could not even have been foreseen at the time the policy was enacted. That's in many cases what we call indirect discrimination, or in the United States, disparate impact. And we've also now, of course, come to recognize systemic forms of discrimination. So policies that together accumulate so that overall there are structures in place in society that hugely disadvantage and marginalize and render invisible certain groups. So I take it for all of these reasons, once we have a much more expanded conception of discrimination, it can't now be the case that discrimination is only wrong when it's done from a particular sort of intention or prejudice. And we're now confronted with these very deep philosophical questions. Are all of these forms of discrimination wrong for the same reasons? Do all of them count as injustices? When there is a wrong or injustice, what is it about discrimination that makes it wrong or unjust? Discrimination causes so many different kinds of harms, on the individuals and groups that are excluded or denied a benefit, it can be very difficult to think about which of those is relevant from a moral standpoint and which ought to be relevant from a legal standpoint. Is it the fact that groups have had their autonomy denied? Is it the fact that some groups are persistently left worse off than others and these policies do nothing to ameliorate that fact? Is it something to do with subordination? And how should we think of subordination? Should we think of it in a more individualized sense, or as having to do with the social meaning of a particular policy, or as having to do with something about the social status of different groups within a society? I try and argue in this chapter that many of these harms are relevant, and that precisely for this reason, it's only going to be a pluralist account of discrimination that will adequately be able to capture the variety of different reasons why discrimination is wrong, the variety of factors that make it into an injustice or a number of different kinds of injustices. And I try and sketch some of the questions that a pluralist theory would face and some of the questions that such a theory has to address in order to give us a successful and rich set of answers to these pressing questions. Thanks.
Thank you so much, Sophia. It's certainly very, very timely, your work in this area. We unfortunately do not have John Tasioulas with us online, so I'll next be turning to Massimo.
As John mentioned, one of the distinctive features of this volume is that it covers a broad range of topics in legal philosophy. Some of these have received plenty of attention in the debate, and others have started to receive more attention only in recent times. So the topic that my colleague Christoph Kleitzer and I address in our chapter is devoted to, the chapter is devoted to the notions of authority and legitimacy. And these notions have been widely discussed throughout the history of philosophy, and in the contemporary debate, they have been central. And so the challenge for us was to write something that would cover the central themes in this literature and the main views that emerge in the long history of these notions. And as I'm sure you know, some of these views have reached an extraordinary level of detail and sophistication. And at the same time, to do so in a way that doesn't merely repeat what other excellent entries on these subjects already say. And so, yeah, this was the challenge: try and cover the main themes, the main views, and not merely repeat what others have said about these topics, and stay within 8,000 words. That was an additional challenge. So one thing that we've done to meet this challenge is to start our chapter by providing a brief historical overview of how the notion of authority and legitimacy have evolved over time. And this is an aspect of the problem that is rarely addressed in the most recent debate. So our goal here was to give a sense of the different notions that have emerged in response to different worldviews that were predominant in various historical contexts. And I think that this is important because the tendency to treat these big central notions like authority or justice or rights that are fundamental, that play a fundamental role in our political discourse, the tendency to treat these notions as fixed is, I think, hard to resist. And it's hard to resist not only for newcomers to these debates, but also, and perhaps especially, for those of us who are fully immersed in a specific philosophical debate. And I suppose the other way in which we have tried to meet that challenge has been to provide an overview of the debate that cover the main problems and the most important views in a way that conveys to the reader the motivation for the different approaches that we discuss. So our focus has been on trying to give a sense of the different moral concerns that underlie the different accounts of political authority that we discuss. So, for example, a classic way to think about a political authority is in terms of, is by looking at the notion of personal autonomy. Is political authority compatible with respecting the demand to have our autonomy respected, to be treated as autonomous agents? And other views focus instead on the capacity of political authority to protect certain valuable moral relationships, perhaps to enable certain valuable moral relationships to flourish. Other views focus on how political authorities enable us to exercise our capacity to respond to reasons, for example. So if we have succeeded, I think the payoff is that it should be clearer to those who approach these questions for the first time why they should care about the notion of authority and the problem of political authority, which might not be necessarily obvious. I think that authority is not like the notion of authority is not like the notion of justice or the notion of rights or the notion of equality. People might disagree about what justice requires, or they might disagree about what rights are, but I think that there is a clear sense that justice and rights do matter. And I'm not sure that authority is like that. It might not be immediately clear why we should care about political authority. So I think that connecting the notion to other notions, to other moral demands that we already care about and that are important for our life is crucial, not only because it enables us to better understand the notion of authority, but also because it enables us to see why we should care about it. Thanks.
Thank you, Massimo. And also thank you to our audience who are providing some really thought-provoking questions in the Q&A box, and we will be coming to those. But just before we do, I give the floor to my colleague, Guglielmo Verdrame.
Thank you, Philippa, and thank you, John, and for organizing this event and for editing this book. I think unlike some of the other contributors, I did spend a bit of time in my chapter dealing with conceptual issues, and that's because I think in international law, you can't avoid the conceptual question. International law works differently from domestic law, and understanding how it fits into the idea of law remains an important inquiry. And so I begin the chapter with a discussion of Hart's chapter on international law and the concept of law. Hart's account of international law is actually more nuanced and I think more open to international law than is often recognized. But nevertheless, I argue that it suffers from two main errors. The first one is that the characterization of international law as primitive law is fundamentally flawed. Hart himself says that primitive law rests on a number of social and political predicates. Primitive law, he says, can operate successfully when you're dealing with a small community that is closely knit by ties of kinship, where there is a commonality of sentiment and belief, and there is a stable environment. None of these social and political predicates are in place for international law, and in fact, the reverse of those predicates is probably closer to the truth. And yet, international law still operates. Some will say successfully, others will say less successfully, but I think few would deny that international law functions in some significant way, notwithstanding the absence of those predicates. So I think it is a grave error conceptually to reduce the phenomenon of international law to primitive law, to think of it as primitive law. The second problem with Hart's approach is that it rests on a doctrinal understanding of international law that is quite inaccurate. And to be fair, he's not the only one who makes this mistake. Dworkin's paper on international law, published shortly after his death, suffers from a similar problem. And the error is this: to think of international law in a doctrinal sense as a consent-based system. It's a very common, but also quite distorting account of international law. It is distorting not only because of Hugh Scogans, but also because of customary international law. In fact, perhaps especially because of customary international law, which is, as we know, general practice accepted as law. There is a difference conceptually between acceptance and consent, and that explains why the bar for establishing the existence of a rule of customary international law has never been as high as having to establish positive evidence of consent from 160, 170 states. And in addition to that, customary international law binds also newly formed states, which didn't have a chance to accept it, let alone consent to it. So I think this idea of international law in a doctrinal sense as being a consent-based system colors the philosophical analysis that follows, in the conceptual discussion that follows. The rest of my chapter deals with questions about the morality of international law, and these questions in international law too will be quite sector specific. The normative questions that arise in relation to international investment law will be very different from the normative questions that will be significant for purposes of international criminal law. A set of normative questions of wider systemic significance, on which I dwell at the end of the chapter, concerns the relationship between international law and sovereignty. And by sovereignty, I don't mean the so-called Westphalian or classical sovereignty that so many people still seem to be going on about. Westphalian sovereignty is a figment of the imagination of international relations scholars. You will not find any evidence of Westphalian sovereignty in the treaties of Westphalia. What you will find instead is a series of very detailed provisions that govern the rights and obligations of the rulers within the Holy Roman Empire. Brendan Sims, I think, quite rightly describes Westphalia as a charter for interference and intervention, which is quite the opposite of what Westphalian sovereignty is supposed to describe. The sovereignty that I examine and its relationship with international law is a rather richer sense of sovereignty. It includes, yes, the state's claim to sovereignty, to authority over the territory, which again was never really a claim to absolute, final and unqualified authority, but it was a claim to authority of a kind. And the second aspect of sovereignty is the claim of the people to authority over their own affairs, so popular sovereignty as well as state sovereignty. When self-determination became part of international law, the idea of popular sovereignty, which had animated resistance to the constituted authority since at least the Dutch revolt and probably earlier, became part of the system of international law too. And that created a series of moral normative tensions within the system between different principles and rules. And I think the key question is really one identified by Rousseau in the Emile as the extent to which the rights of the federation, he meant obviously the international federation, could be stretched without destroying the rights of sovereignty. And by sovereignty, he too obviously had in mind an idea that contained an important moral content rather than a simple claim to be the final arbiter. So that's briefly the sketch of my chapter, and I think we've been also asked to include a broader reflection, and I'll just conclude on that. International law has a unique relationship with philosophy. In the modern era, it emerged as really the the work of practitioners who were also philosophers, and Grotius is obviously the main example of that, but also in the 20th century, some of the leading figures in international law, from Hirsch Lauterbach to Miles McDougall, were extremely sophisticated thinkers as well as excellent lawyers. And I think now more than ever, international law needs very serious philosophical scrutiny. So I welcome the opportunity, and I hope that more and more of you in philosophy, political and legal philosophy, will be interested in international law. Thank you very much.
Thank you, Guglielmo. Well, we look forward to your freestanding monograph on this topic in due course. So now we move to the question and answer session, and we've had some very interesting questions coming in, which I am going to assign to our different speakers, and where the person has identified themselves, the questioner, I will read out their name. And I might turn first to John Tasioulas. So Susana Davalos from Mexico City has said that this is the first time she's hearing about the philosophy of private law and finds it very inspiring. And she asks, does it have to do with the aftermath of the 2008 financial crisis and inequality?
That's a very interesting question. I think that when I think of some of the leading contributors to philosophy of private law, I think of people like Ernest Weinrib, Jules Coleman, Charles Fried. They were writing in the 80s and 90s already. So I don't think we could say that the stimulus was that particular financial crisis. I think maybe what was going on was the more general tendency of philosophy to become more specific. So we see philosophers now tending to identify themselves more with the subfields. That's a general tendency. And I think one of the ways that general tendency played out was in legal philosophy, for people to start focusing on discrete areas. And one of those areas was private law, because not a lot of work had been done there compared to, for example, criminal law, or perhaps compared to constitutional law. I think another dimension here is probably the fact that it's an indication of the maturity of legal philosophy as an area, that as it developed, it wasn't simply general questions about the nature of law, but also questions about discrete areas of law that became prominent. And so inevitably, if that's what happens as a field becomes more mature, then you will no doubt identify private law as one of the central topics to be discussed. But maybe Daniel has some thoughts about how it is that philosophy of private law emerged.
Well, John, I think you're clearly right that obviously people like Jules or Ernie predated the financial crisis, but I do think there is a relationship of the following sort, at least in the United States, which is different from the UK and Canada and other Commonwealth jurisdictions. The self-confident intellectual hegemony of economic approaches to exchange, investment, and allocation meant that people who were more philosophically inclined found it very hard to get a toehold in private law subjects. And the first political and then intellectual recognition that law and economics of a particular sort neither had all the answers to fundamental questions about legal relations involving things, investments, and exchange, nor was leading society to a particularly appealing practical outcome, I think did open up space for people who were philosophically inclined or sociologically inclined or in other ways humanistically inclined to re-enter a field that had been previously closed off to them.
Thank you. And Daniel, while I have you on my screen, there was a question directed both to you and Sophia, so I might ask it to you first and then we can turn to Sophia. So this is from Martin Wagner. He says, you spoke about the hermeneutic method in the philosophy of private law and the issue of systemic discrimination respectively. How can the hermeneutic method and the pluralist account of discrimination work together to help us address the inequality we are experiencing today?
Well, maybe I'll say something very brief, And then, Sophia, I wonder how you react to this as well as to the question. And there was also a question on the chat about property. So one of the features of naive private law accounts of property is that they make property scale blind. So they create the impression that the school teacher owns her house in the same way in which the doctor owns her retirement portfolio, in the same way in which the billionaire owns her enormous foundation assets and complicated web of claims. But interpreting those legal relations closely shows that there's a fundamental difference, which is that the school teacher and the doctor are both law takers in the sense that they are unable to deploy their property entitlements to intervene in the system of regulations that governs those property entitlements. Whereas the billionaire is in significant measure a lawmaker. She can use her property to intervene in both the lawmaking and the regulatory administration and the judicial application of norms to her, so that for her, property becomes a feedback loop in a way in which it's not for the others. And that's one of the things one sees by closely interpreting the structure of legal relations surrounding property. And here's where, in some sense, I'm inclined to hand over to you, Sophia, but that recognition shows that equality norms and non-discrimination norms, when applied to material relations, produce a very distinctive critique of concentrations of wealth and of oligarchy. And I could say more about it, but I'm not the best person to say that. So I will stop there.
Sure. Thanks, Daniel. That was really illuminating. Yes, I think it's right that in order to try and understand why discrimination is wrong and what is involved in causing and sustaining particular forms of discrimination, we do need to look very closely at the structure of particular legal relations. I might add, though, that, of course, discrimination and discrimination law are difficult in that it seems to me that while I can understand the deep importance of focusing, for instance, in detail on the structure of the legal relations created by contract law or property law or tort law, discrimination law is a mixture of private and public law, and questions about what makes discrimination wrongful raise difficult moral questions that sometimes have a legal analog and sometimes do not, and it's often difficult to figure out when the law is standing in place for a particular moral problem or when a legal problem has a moral analog, and when a particular legal structure is just doing something totally different. Those, to go back to John Gardner for a minute, those of you who are familiar with his groundbreaking work on discrimination will know that he was quite a maverick. He argued that actually we may think misguidedly that legal prohibitions on discrimination track some important moral truth or set of moral truths about when discrimination is wrong. In fact, he argued they actually create that truth, but they don't track any independently existing truth. And he argued that certain features of the law actually are distinctly misleading. They can lead us to think that there's been some prior injustice done when in fact there hasn't at all. So discrimination law is complicated, and I'm not entirely, I don't think that the same kind of isolated look at the structure of the legal relationships involved in discrimination law that we engage in when we do that in property law and tort law and contract law is so productively done in the case of discrimination law for these reasons. But that said, I do think it's important to look at the legal relations and also at social relations. One of the things I've tried to urge, both in this chapter, but also in a book I've had that just came out during lockdown, so it has only recently been released from the OUP warehouse in Manhattan. I try and argue in this book called Faces of Inequality that we need to think very deeply, much more deeply than philosophers have done, about what social subordination involves. What is it exactly for a whole group of people from a social standpoint to be the subordinates of others. Clearly, it involves them certain kinds of power relations, certain relations of authority that one group has that another doesn't. Nico Kolodny, the political philosopher from Berkeley, has argued that it also involves what he calls a certain kind of consideration, which means a certain kind of deference given to the views of one group over another. And I also argue that there are things that I call structural accommodations, perfectly ordinary rules and practices in everyday life that tend to favor the needs and interests of certain groups over others. But I think we need to look at all of these things in order to build up a very rich account of what social subordination is. And it's only once we have that, for instance, that we can really understand what systemic racism is in the United States or Canada or the UK.
Sophia, could I ask you a follow-up question that's come in through the Q&A box anonymously? Yeah. Do you think that the right against discrimination should be considered a human right distinctive from other rights?
Yes, I think that's a great question. I take it that question is coming from the following standpoint. You might think that discrimination isn't in any way distinctive, that there's no right not to be discriminated against, because you might think that we show everyone the right sort of respect, or we treat everyone as an equal, provided we just give them whatever it is they already independently have a right to. So if we determine, for instance, that everyone has a right to freedom of speech, a right to practice their religion, a right to vote, certain legal rights, we can make a list of all of the rights that everyone ought to be given, and provided we equally give everyone all of those rights, there's nothing then to say, or rather we have shown everyone the appropriate respect and we haven't discriminated against anybody. I don't think myself that's quite the right way to think about it. So I do actually think there is an independent right not to be discriminated against. And this goes back to what I was saying a minute ago about the right to be treated as the social equal of others in your society. So I think that in order to ensure that that everyone is not discriminated against, we have to ensure that nobody is treated as the social inferior of others in their society, and that it will involve a complex set of things involving looking at the way power is distributed in a society, the way authority is distributed, the kind of autonomy that's given to certain members of society, but not others. So I do think that the right not to be discriminated against has this distinctive content, and that it depends on what it is to be treated as the social equal of others.
Thank you so much. I now have a few questions that have come in for Honora that I will read out. So the first one comes from SA. And they ask, coming from political philosophy, what would you say could be a blind spot in the field of legal philosophy, more specifically in subfields such as constitutional theory, which overlap quite a bit with political philosophy?
No, I don't think I'm very well equipped to answer that one. I don't read enough constitutional theory. I don't read enough philosophy of law. So what are the blind spots? I'm sure there are lots. There are in every field, but I wish I could get a handle on that, but I don't think I can.
No problem. There's a whole stream of questions for you, so I have more I can turn to.
Let me see if I can deal with the others.
So, Jennifer Masse of Germany says, in the rise of positivizing human rights, did you identify stable factors of law that could be assumed to be a manifestation of ethical principles? And if so, how could they be related to the duties to be fulfilled towards future generations?
Well, that I perhaps can have a go at. I think one has to see what you correctly call the positivizing of law as something that took a very long time because it doesn't quite work, so one thinks a little bit more, a somewhat clearer tying down of the duties of various office holders will get us there. And of course, one of the puzzles is why more has not always proved to be a solution to the problems that were seen in the first place. I don't say that it is always wrong, but I think it is, what shall I say, a distracting thing to imagine that the institutionalization is going to solve what is, in my view, a deeper problem which is that we've got a plurality of principles. If we were working within a certain sort of system with perhaps a mathematical structure, we would say, well, it's like solving a simultaneous equation, isn't it? You find a way of respecting this principle, that principle, and other principle, hey presto. Unfortunately, there will be a lot of ways of doing that, and there will be sometimes no ways of doing it. So I think that thinking more about judgment, and who am I to say that to lawyers, might be quite important here.
Thank you. And we also have a question from Susana Davalos of Mexico. She says, inequality is an issue debated everywhere these days. Could you please tell us more about the duty of generosity that you talked about?
Well, I'll say one obvious thing about the duty of generosity. It is what is classically known in theories of duties as an imperfect duty, which means that you don't have to be equally generous to everybody. That would be a very different situation if it were a perfect duty, and maybe you'd have a duty like that. But therefore, generosity, you are allowed to be, if you like, capricious. You can be kinder to one person than to another. Now, some people who are thinking perhaps mainly of perfect duties will think that that's outrageous. We don't want people to be behaving in a way that distinguishes between different claimants. But that is what imperfect duties are. And generosity is, of course, not the only one. There are lots of imperfect duties. And it seems to me a pity to imagine that we have gained something by writing them off the map or shoving them off the map.
Thank you so much. I now have a couple of questions for Guglielmo Verderame. So one question from Selina Mowat is, although you dismiss the Westphalian model of sovereignty, is it possible to admit that the role of popular sovereignty and self-determination have their limitations in international law, as exemplified by using both Palestine and Somaliland?
Well, they certainly have limitations, both at a level of principle and certainly at the level of practice. I think the examples of Somaliland and Palestine would point in the direction of limitations at the level of practice, if I understand the question correctly. I certainly wasn't suggesting that there is perfect compliance with self-determination in international law today. It is evidently not the case. Nor was I suggesting at a theoretical level that self-determination has become Westphalian and absolute. That isn't the case either. And the limitations of that international law itself places on the right to secession would be an example of that. I think what self-determination does is connect the rather dry sense of sovereignty in international law as just state sovereignty with a deeper and I think morally and politically more significant sense of sovereignty that had been part of the political landscape for centuries. International law had taken little notice of it until self-determination entered the scene. It had been the language of resistance to the Ottoman and Habsburg empires in Europe in the 19th century and to the colonial empires later. But it wasn't until Woodrow Wilson in 1917 put it in his famous 14 points that it actually began to become part of international law. And I think that has changed the way in which states are sovereign and the way in which peoples are also agents in international law. It has made it more politically dynamic and I think morally responsive to a wider series of interests and values than would have been the case before.
Thank you so much. And we've still got many interesting questions, but we are getting ready to turn to our panel on teaching. But I'll conclude with a question from Jordan Walters, directed to John Tasioulas. So this is a question about the relationship between philosophy and human rights law. What role should philosophy play, if any, in theorizing about human rights law? For instance, Bates, in the idea of human rights, takes issue with Nussbaum since she endorses a naturalistic theory. The problem with naturalistic theories, as Bates sees it, is that they assume that the philosophical theory is authoritative for judgments about the proper content of international doctrine. But there is a difficulty in explaining why this should be. Should philosophical theories be authoritative? If so, why? If not, what else? And in 2 minutes, please.
Thanks for that incentivizing deadline. What I would say is that there's a kind of ambiguity in the discussion of what a naturalistic theory is of rights. So one interpretation that Bates uses is the interpretation that says natural rights are the rights that we would possess in a state of nature. And for the sort of hermeneutical reasons that Daniel talked about, he says this is hopeless for thinking about contemporary human rights, because contemporary human rights include all sorts of rights, rights to a nationality, rights to a fair trial, that you couldn't possibly have in a pre-political state of nature. Now, of course, that's only one understanding of natural rights. There's another understanding of natural rights that doesn't say that they're rights we possess in a state of nature. They are instead rights that we can identify as rights that we have through natural reason, not because they're established in law, not because they're established in convention, but because our reason identifies, for example, that we have a certain kind of human status, and part of that would be that there is a right not to be enslaved, a right not to be tortured, and so forth. And at that point, I guess there's another complaint coming from Bates as a Rawlsian, which is we can't really purport to put objective truths in a position of judging political doctrines like the doctrine of human rights, because reasonable people disagree about them. Now, that's obviously a major debate in contemporary philosophy, whether we do need to rely on an objectivist account of reason to justify ultimately legal doctrine, or whether legal doctrine can somehow float free of that kind of issue of objective justification. The worry that I would have, and I've articulated in my work, is the alternative posited by people like Rawls looks like an explicit parochialism. It looks like it's saying, okay, I'm forswearing reliance on objective reason. What am I relying on? I'm relying on ideas deeply ingrained in liberal democratic tradition, but I'm not claiming that those ideas have any kind of objective backup. But if you're not claiming that, then why aren't you simply in the business then, according to your own telling, of imposing your tradition on those who flout human rights as you understand them? So it seems to me you need to have the objectivist basis if human rights law is to legitimately claim the authority that it claims to have, i.e. to govern even those who reject liberal democratic ideas. Thanks.
Thank you so much, John. So with that, that brings to a close the first part of our event, which is the launch of the Cambridge Companion. I thank our speakers and our audience for those thoughtful questions. I also congratulate our editor and the contributors for this wonderful book, so urgently relevant. And we now turn to the teaching of jurisprudence, chaired by Christoph Pletzer. Thank you.
Thank you much.
Thanks. Actually, it's chaired by Jonathan. Can I hand over to John? Thanks a lot.
So yes. So we'll be talking a little bit in this panel about the teaching of jurisprudence, particularly at King's and also more generally. We'll be speaking. I'm a lecturer in philosophy of law at King's College. I'm here along with Dr. Christoph Pletzer, a reader in law, and we also have with us 3 students, Lawrence Ramsauer, currently a PhD student in the philosophy department at the University of Chicago, and a 2017 graduate of the Politics, Philosophy, and Law LLB. Tasneem Bint Ghazi, who has just completed the LLB in Politics, Philosophy, and Law at King's College, I believe. and Yewande Oyekan, who has just completed the LLB at King's and will be studying at UCL for a master's in legal and political theory next year. So we're delighted to have all of them with us. And so I think we'll kick off by Christoph saying a little bit of context about the teaching of jurisprudence.
Thanks a lot, Jonathan. So it's such a great pleasure to be here and have this illustrious community of people talking internationally about jurisprudence, because jurisprudence is quite important at King's. We have a very strong team. We have a kind of we can hit quite a punch in jurisprudence at King's. We teach jurisprudence, of course, in the LLB program. So in the third year, jurisprudence is compulsory. At King's, we decided, I think, quite consciously that it's important for students to have an understanding in jurisprudence. I'm going to say a couple of words about that. And the jurisprudence course is a third-year course. It's compulsory. All our LLB students have to take it. And it starts off, despite, of course, John's diatribe against general jurisprudence, you have to do a bit of general jurisprudence, I think, at the beginning. I think there has to be a balance. Just when you asking, well, how does France look like? You say, well, it's a hexagon. So that's, of course, not accurate. But it does look look like an hexagon, and then you have to take it further. Then you have to zoom in, maybe to if you look at the boundary of France, how does the boundary between France and Belgium look like, and how does it structure itself, and what's the boundary between Germany and France, and how has it moved? And then all these specialized studies can start. But at the beginning, I think it's fair to say, well, France is a hexagon. And in a similar way, you say similar silly things about the law and morality and authority and justice and many other of these topics, which are just, of course, in the beginning prolegomena. They're just attempts to set down, the debate. The attempts to introduce or to the students to a couple of ideas that have been thrown around and that have happened to fill libraries. And of course, every couple of decades, certain aspects of these libraries are, rendered waste paper and said they're irrelevant, but then they come up again and then they're discussed again. And many of those questions are hard questions, like in philosophy, they are just hard questions. We just can't seem to answer them, like the nature of consciousness. So the question about the nature of law and morality does seem to be, still, even though it comes up in different guises, different questions, different formulations, it seems to be a hard question. And people tend to disagree fiercely about that. So we discuss these things in the nature of law. Even though it's a silly question, I think it's an important question, and we discuss that. But then we move it on, of course, jurisprudence, to topics which are closer to be understood as hermeneutic, as Daniel said, I think, as coming from the bottom up, from this various fields of law, and not just a general theory of law, which could also be understood as in German you call it the allgemeine Rechtslehre, which is a general theorizing of law from lawyers doing that, not philosophers from the top down, but like speakers of a language that you reflect on the grammar you're speaking in, and similar as lawyers reflect on, well, what's this thing that we're talking about? What's this medium we're swimming in? And but that gets, of course, more detailed. And in the second semester, then there are many options students can pick from, where you can discuss topics from tyranny and dictatorship, which is my topic, Shakespeare and the law, obligation, criminal law, many topics, very specialized. But apart from the jurisprudence module, we also have the PPL program, which is a specific program, and we have the great honor that two of our students who have just graduated this magnificent program to have them with us, and I'm going to hand over to them in a minute, but I'm just going to say quickly what that is. It is a program co-taught by the law department, the philosophy department, and the political economy department. And students not only get the smallest common denominator of these three departments, but they get the full breadth of them. Lawrence scored very highly. I'm sorry, I have to out you in logic. So you don't just do political philosophy and legal philosophy, but you actually do formal logic, philosophy of religion, ancient Hindu philosophy, whatever. So you do these things and you do political philosophy, and then after 4 years you graduate with a qualifying law degree. So this is, I think, philosophy of law in its fullest. Now, to stop me going on about that, can I just hand over or ask the first question, first of all, to all three of you, but I'm going to start with Lawrence, to ask him what he thinks that jurisprudence has changed his view or altered his view. What has it contributed to his understanding of the world or the legal world or the law or anything like that? Please, Lawrence.
Thanks. Well, first of all, thanks for having me. This is a real pleasure. That is a very difficult question. I am absolutely convinced that the most important ways in which it has changed my way of thinking about, I don't know, philosophy in general or the law are ones that I don't even consciously realize. Now thinking about it, I think the most striking difference to me between political philosophy on one hand and jurisprudence, do we remember is that in a lot of other philosophical subjects, what we're dealing with are very obvious questions. As in, obviously not the answers are obvious, but the questions are pretty obvious. So they almost ask themselves, what is a just distribution of wealth in society? Or what are the limits of free speech? I don't know if you think about political philosophy. Whereas in jurisprudence, they are usually questions that they seem very innocuous. You don't usually tend to go about your daily life and then think, well, where does legal validity come from? Or what is it for someone to bring about something else? If you're somewhat normal, you usually don't do that. But it turns out in jurisprudence that all these things are horribly complicated. So one of the things that for me jurisprudence did was, so they instill a bit more of, let's call it epistemic humility, that things are much more complicated than they are, even when it just really doesn't seem at first that they will be that complicated. Especially if you're practicing law, or if you're somehow already studying it, you're engaged with all different kinds of legal questions, you might simply have a whole lot of blind spots that the study of jurisprudence, I remember back then, really helped me, well, maybe not see all of them, but at least get a sense for what they might be. That's the first thing that comes to my mind.
Great, very interesting. So Tasneem, maybe can I move over to you? Why would you recommend somebody? I mean, if it were optional, if jurisprudence, why would you recommend it? What would you tell them in your own experience, or would you say don't do it?
Well, obviously, thank you all for having me. First of all, I would say that probably the most valuable module in terms of the skills you're taught for a law degree and even for a political science degree is jurisprudence, because of the way it's taught at King's and the skills that students derive. So with a straight law course, you're taught, the emphasis is on substance, the emphasis is on statutory interpretation, it's on engaging with judgments. In jurisprudence, you're taught how to think. The first term is obviously really generalist. You're talking about what constitutes a good law, morality, law and goodness. But then you look at very specific questions like crime and punishment, or your kind of module on tyranny and dictatorship. I think the reason why it's so crucial is because students come out being able to make their own normative arguments that justify their view of the law. And they come out with an ability to understand how to make a strong philosophical and legal argument. And it sounds pretty cliche, but having this multidisciplinary perspective is extremely valuable for any career, in my opinion. And it's also important when you read, when you write, when you think, and when you look at a text, when you look at a philosophical text, because ultimately you ask, and as Lawrence was saying, you ask very different questions, and you learn to reason, you learn to look at both analytical and normative jurisprudence, you learn to engage with the nature of a concept. So it's you make an epistemological argument along with a very kind of basic normative argument. And so yeah, I'd say it's the skills that it teaches students. It teaches them analytical rigor, and it teaches them the ability to make an elegant philosophical argument, which you don't get in a normal law degree, or you don't get just studying kind of straightforward law. But yeah.
Great, fascinating. So over to you, Yewande. I gather you're on your way to UCL to do actually an MPhil in legal and political philosophy. So you're an absolute expert. So what has made you choose that, and what do you think is the importance or the relevance of jurisprudence?
I think from a more sort of like practical level, studying the law, like doing 2 years of very, very full and like robust modules, it gets very difficult to see what the point of the study is, because you get completely bombarded by these cases and principles and rules about things that seem very complicated and so far from the real life practical impact of the law. So it gets very difficult to answer the question, really, what is the point? Because you spend long hours at the library, long days on campus, you know, going to lectures and tutorials. And for someone who, you know, you set out on a law degree thinking I have a purpose, not purely because, you know, you had the whim to, that purpose can get very, it can get overshadowed. So studying jurisprudence, which forces you to ask questions like, what is the purpose of the law? Why does the law take this shape, or what shape does the law take? It can reinvigorate the actual pursuing or the pursuit of an undergraduate degree. And I think on an intellectual level, I think it serves us all to question why we do things the way we do them and why the systems we have in place have taken the shape they have. And those questions can really only be answered from a theoretical perspective if we want to sort of arrive at the right answer, or the right answer for us at this specific time. And so that's why I personally really enjoyed studying jurisprudence, and why I chose to go on to study legal and political theory.
That's great. That's great. So I mean, one of the obvious questions that the students ask us, I mean, the three of you here kind of, it wasn't on purpose, all have kind of an interest in jurisprudence, it seems. So we don't have one going to a city law firm. But let's try, at least for the sake of the, as an exercise, when you, Tasneem, maybe you, when you remember colleagues, or if you want to go into practice, what do you think do you think that jurisprudence is helpful there, or is it just an exercise in intellectual navel gazing? Is it kind of ivory tower thing stuff, or is it of relevance to legal practice? What's your view, and what's the opinion, do you think, in the student community about that question?
Yeah, sorry, it's just my headphones didn't seem to work. But yeah, so going back to what you were saying about why jurisprudence is essential to practice. I mean, the Miller case is an obvious example. How do you justify executive accountability? You know, you need a very robust set of principles, and you can't engage, or you can't even describe what constitutes the separation of powers, or a constructive view of the separation of powers versus a pure view, or parliamentary sovereignty, without having any knowledge of jurisprudence. Jurisprudence is essential for administrative law, for constitutional law, and even for private law, for justifying what is a good contract. So at least for me, from my perspective, I do want to go into practice, or I hope to go into practice in the long run. But as I was saying, analytical rigor is essential for a strong legal argument, because ultimately you're dealing not just with a set of facts, but looking at the facts and making a coherent argument. And your argument has to make sense philosophically, and it has to be free of logical fallacies. And I don't think they teach you that in straight law. You're not taught what a logical fallacy is, or how to make a neat normative argument in EU law. I mean, EU law is great, but you are taught this in jurisprudence. And that's why it's essential for every student, in my opinion, whether they're going to be a solicitor or a barrister, because of the skills they derive from it. They're able to derive analytical rigor and precision, and to make a conceptually grounded argument. That's my take.
That's fascinating. That's really fascinating. And I do think that Brexit, at least in the Great Britain, has given us, the best sales pitch for jurisprudence. I think I found out my students from the PPL program and also jurisprudence students did a great job at debating the legal intricacies in the Miller case and many other topics than people who have not gone through that. I mean, my sales pitch has always been for PPL and jurisprudence to say, well, you know, you need jurisprudence when the law runs out. The higher you get up in the hierarchy of law, the less, you know, the black letter law will matter, and the more arguments will matter that you learn and that you are confident that you can present. Of course, saying the law runs out is itself a jurisprudentially contentious way of speaking, because for some jurisprudence the law never runs out. But in a practical sense, you know, I think the higher you're up in the legal hierarchy, the more important jurisprudence could get. Lawrence, would you agree with that?
I think in general, yeah, I would agree. Actually, you mentioned something about, yeah, the practical value of jurisprudence. So maybe I'm the wrong person to ask you, because I ended up doing a PhD in philosophy. So this might be a very different take. But one of the reasons why I do very much like this way of studying law or jurisprudence, namely in this PPL degree, is that it does precisely the opposite of what a lot of people in the UK and the US are calling for, which is to make legal education much more practical in a very, I think, negative understanding of the sentence. And ironically, that has very good consequences. So sorry, this might sound a bit cryptic, but let me explain. I mean, what I remember from the UK, and for that matter, right now in the US, there is this kind of constant complaint about legal education just not training future lawyers well enough. Because it turns out that lawyers very often just argue about the facts, and hardly ever, unless you're working at, well, in very few jobs, really argue about the law. And people in the UK, especially the law and context movement, right? All of these people have been arguing, well, we should make this whole legal education thing more into some kind of a job training exercise. People need to be more prepared for the actual jobs that they will hopefully have. And I think the great value of studying jurisprudence is going the exact opposite way, which is to accept that actually there's a whole lot of wisdom in the law, in the way that we have actually built all of this, and in the ways in which it came about. Understanding this is really helpful. And studying it in this kind of more political, theoretical, philosophical perspective, then turns out to have some practical beneficial consequences as well. In a way, I think it takes the study of law towards the opposite side of the making it more practical approach, right? It makes it more into, it brings it closer to a, let's call it a humanistic ideal of education, right? I don't want to use the term liberal arts education, but it gives it somewhat more validity as its own academic subject. And I think that's actually incredibly helpful, especially for lawyers, for future lawyers, but for that matter, for anyone else. I think even if one does not go into practicing law, studying law and philosophy and political theory is incredibly helpful. So I think that is an important way of thinking about, or it's important to have this broader way of thinking about the practical consequences or benefits that we can get from studying jurisprudence.
Great, I agree. It is of course, it's no surprise you're Austrian, I'm Austrian. That's a bit the way we teach the law on the continent in Austria as kind of the paradigmatic humanities subject, which is a purpose in itself. Just studying law is interesting, whether you practice it or not. You understand the history and the stakes and the grammar of a society. So. But when I have you now, so you said you're moving on to philosophy, and that's the other side of the coin. How much do you think understanding law important for studying philosophy? Is there do you think a benefit you have? Is there an advantage you have over your colleagues who are pure philosophers? Is there an edge you think you have?
And to some extent, there definitely is. Whenever it comes to topics like political philosophy, or for that matter, philosophy of law, there's a very obvious benefit in that regard. Generally speaking, I mean, the place in which I ended up now is perhaps not the best example, because only the weird people end up at the University of Chicago. So it's one of the universities that is just incredibly happy about everything interdisciplinary. So very often it happens that in my program, the people come join the philosophy, the graduate program, who have somewhat idiosyncratic or different backgrounds, and who want to do somewhat that has some connection to either political theory, political science, linguistics, or law. And now what is very helpful for me is that I'm actually working with people also together sometimes at the law school. So there is a clear benefit that I'm now getting from it. If my interests were only in, let's say, formal epistemology or only logic, I mean, that would have been, then I think I wouldn't have needed to study jurisprudence. But I'm in general always in favor of having a somewhat broader background. I think it makes you a much more healthy person. I think it's overall, it makes you a more interesting thinker or philosopher if your background is not just the very boring, philosophy syllabus that you find at any university. But of course, I'm also horribly biased in that regard, so you might want to take this with a pinch of salt.
That's great. So, Jonathan, I'm gonna hand back to you. So let's see if there are any questions from the audience. I think John has asked one, but it's you're in control again. I think you're muted.
We don't yet have any questions from the audience about legal education, although people are very welcome to ask any that they have, and we will address them. Maybe I'll ask, sort of picking up on the last point, or maybe picking up on the last topic that Christoph and Tasneem discussed about sort of practical implications of law. I was wondering, maybe this is a question for Yewande. I was wondering if, for the students on the panel, if you feel like studying jurisprudence or philosophy has changed how you approach thinking about law in more doctrinal contexts. When you've studied legal philosophy, does it sort of like an isolated thing, or are there things that it changes about how you think about labor law or intellectual property law or anything like that? Do you have any thoughts on that, Yewande?
Well, I'm not sure if it's changed the way I think in terms of how I go about studying any of those modules or how I did, but I did find that certain things that I read, say on my moral philosophy module or during jurisprudence, did have an impact on what opinions I had in other modules. Like, I've personally always found the theory of, say, criminal law or labor law more interesting than the actual statute or the black letter law, but that's a personal bias, I suppose. And I found that certain things did personally change my opinions on how a certain case was decided, particularly because it would change how I thought about the nature of things such as obligation or legal relationships and the nature of, say, duties and rights and entitlements, which I think make up the majority of the study of law. So I think on a case-by-case basis, it did change how I went about things, but not from a sort of general perspective.
So some of the impact that you when you think about philosophy of law is thinking about sort of jurisprudence as a normative framework for the moral or political evaluation of questions that courts face or legislators face when they're making legal decisions.
Yeah, and I think also sort of questions in general jurisprudence kind of lead you to think about decisions or not decisions, but perspectives on the law that are espoused in judgments in a certain way, where you find some judges believing that their job is to merely apply the law. They try really hard not to frustrate the intentions of Parliament, and that would only come from a specific jurisprudential perspective, and the way I would respond to that case would change depending on, I don't know, what I had read. If I had read something particularly convincing on maybe a positive perspective or a natural law perspective, maybe the week before or the day before. So I did find it really interesting on like an intellectual perspective to see where the dots connected and what sort of opinion I had on how the law should be, really, and not really about what it was or what it is.
Tasneem, did you want to get in on this?
Yes, please. Hang on.
Oh.
You're off again.
You're muted.
You're muted again.
Sorry.
There. Oh.
Again.
Sorry, slippery fingers. So what I was going to say is it has definitely changed the way I look at law. And I think it's important that they teach jurisprudence in your last year, because you're not actually going to know enough about the substance of law or you're not going to actually think about what is good judicial review, when deference is necessary, when judicial intervention is justified, until you've finished 3 years of solid law. And so I think first, it's important that it's taught in your last year, right before you go to work, so you can make those neat conceptual arguments. But it definitely gave me a different perspective on something as broad as judicial review. So what makes good judicial review? What makes deference? Is deference something desirable? What is deference? Why is deference not desirable as you know, a judicial approach? So I think in terms of understanding different judicial approaches, you know, techniques of judicial interpretation, what are good principles of legal adjudication? So what should the court's responsibilities be generally, and what is something that you can't really look at if you haven't looked at jurisprudence beforehand. So that's the first thing. And then the second thing I'd say is logical fallacies. It's a small point, but you're not going to be able to be consistent within your philosophical reasoning unless you've taken jurisprudence as a law student. At least that's what struck me, because, you know, taking formal logic like you, Lawrence, was very good in terms of teaching me how to reason well. But I think in terms of looking at it, if I'd just done straight law, I wouldn't have known how to reason consistently in an elegant conceptual manner had I not taken jurisprudence. But yeah, there you go.
So maybe so we now have a few questions from the audience. So maybe we'll go to a few of these and see if any of the panelists have thoughts about them. From John Tasioulas, we have a question for all of the students, which is that the Cambridge Companion shows that the philosophy of private law is a thriving area in current legal scholarship. And he wonders if thinking about the philosophy of private law has helped you in your study of private law, and whether your lecturers draw on ideas in the philosophy of private law. I take it when they're presenting doctrinal material about private law.
Now the question is, who wants to go first?
Tasneem?
Okay, I'll be brief. Taking jurisprudence made me a utilitarian. I'm really sorry, John and Christoph. So taking private, I mean, when I did kind of taught law at the same, and property and trust in the same year as I did jurisprudence. And so I think I'm not the best person to speak about this, purely because taking jurisprudence made me a bit of a utilitarian, in the sense that I preferred public law, and I preferred public law because I was able to apply my knowledge of jurisprudence. So I defer this question to you, Lawrence, and you.
Am I unmuted? I think, yeah, okay, this works. So I think my perspective on this is, again, slightly different, because now I'm not studying law anymore, and now in philosophy. So it might be the opposite way, but there is something very interesting right now happening in philosophy, which is that there is a reviving interest in Kant's doctrine of right, especially in the Anglophone world. And interestingly, a whole lot of private law theory, especially think of people like Weinrib, they're now becoming all of a sudden an interesting source for the philosophers. So this is, I think, a fairly new development that within philosophy, people are now all of a sudden looking at what people in legal theory are doing, or especially in the philosophy of private law. I have to admit, I have just simply not studied the philosophy of private law properly when I was an undergraduate. So I just simply cannot say anything about whether my views on private law have changed at all. But overall, I think my views on, and this might be a little too unorthodox to be said aloud. I'm actually a Kantian by now. But this happened, I think this actually happened in, during my undergraduate degree, because when I was taking courses in the philosophy department with John Callinan, who's a great teacher, really highly recommend taking his courses. On first the critique of pure reason and then Kant's moral philosophy, I ended up all of a sudden being a Kantian, and so far I haven't really gotten rid of that. So I might have, I might be, a bit more biased towards these philosophy of private law scholars than you, Justine.
Yeah.
I don't know that I got so much exposure to the philosophy of private law during my undergraduate degree, but there is some degree to which you do study that, because most modules tend to have a so you tend to do an essay which is more focused on the theory. Like at least in first year we did have seminars where those were purely theory based or like philosophy based, where the lectures were more about the doctrine. And I did find that it did help answer certain questions, or at least bolster your argument in essays coming from a position in which you did have some knowledge on the philosophy of private law, because you could sort of mold your arguments based on that knowledge. But other than that, I'm not too sure that it's really changed my mind so much, or really like illuminated anything specific about private law to me.
Yeah, Tasneem?
I think I just want to add that, okay, am I live? Okay, yeah, I just want to add that we were taught, so I think it's important to give credit where credit is due. We were taught the philosophy of private law. I think if I were to summarize what I meant to say is I just wasn't very interested in it, because I love doing public law and I wrote 2 dissertations on public law, and so I was really interested in public law. But we were taught the philosophy of private law, and I think for taught Professor McGrath and James Lee tried to get us to engage in these sorts of questions. It just wasn't something that I did. Yeah, that's it.
Interesting. So there's another question from the audience that I think would maybe fit nicely with this. So Visa Kurki asks, as a teacher, I find it hard to strike a balance between the big picture questions about history of jurisprudential thought and the different schools and so forth, versus careful examination of individual problems, topics, thinkers, and so forth. Are there any thoughts on how to thread this needle? So this is maybe a question for Christoph or for any of our students. How do you feel, how should questions that are sort of about specific topics in jurisprudence or legal philosophy best balanced with questions about big picture things like what is the nature of law? And maybe this goes a little bit to John's discussion in his talk at the beginning of the last panel about the emergence, sort of the renaissance in philosophy of specific substantive areas of law, and also to the last question about philosophy of private law. How does one integrate the study of broader questions that maybe are not about specific areas of law with these more isolated philosophical questions like what is the ground of promissory obligation in contract law, or what makes a constitution legitimate. So is there anyone who would like to get in on this question?
I'm happy to jump in quickly, of course. Of course, I mean, much is answered by judgment and trial and error, and you just move back and forth between the different topics, and it's a kind of a question of economy, of course. I mean Hegel famously said that the difference between private law as a legal positivism and natural law is the difference between the institutes and the pandects. So whoever has studied Roman law and has had a look at the Justinian Code, you have on the one hand the infinite sea of complexity of the pandects, which is just a collection of detailed legal wisdom. And then on the other hand, you have the institutes, which are just a collection and attempt to come to the grammar, the principles to abstract something. I think, of course, you need both. Students do study the law. They do. I think jurisprudence. A point of jurisprudence, I find, is to also reach the highest point of abstraction and try to ask the question, well, what is law? I think one shouldn't avoid that, but one shouldn't be fixating on that, of course. So I'm afraid the only answer I can give to Visa from my point of view is just by trial and error, and don't be dogmatic. Don't focus either on one or the other to the exclusion of the other, but try to kind of put together, you know, a comprehensive picture that includes all of these elements. It's not a very exciting answer, but I think it's a correct one.
Is anyone else? Yeah, Lawrence. You're muted, Lawrence.
Sorry, but okay. So obviously I've never taught jurisprudence, but at least I've had the pleasure of sitting in on 3 different courses on jurisprudence at 3 different universities. And I've now, I think the only thing that matters in regard, well, the most important thing as an answer to the question is that, unfortunately, unless we can make the jurisprudence course last 2 years, at least, we'll have to accept that it will be very imperfect and that there is some failure involved necessarily. Personally, the one thing that I found most frustrating is that a lot of jurisprudence, as I've seen it over the years, being taught to not just undergraduates, but also to JD students, is somewhat watered down, and people are trying to fit people into boxes because that makes it so much easier to teach them. But of course, the problem is that then you end up with students who know which box they want to put, I don't know, let's say John Finnis and Joseph Raza, but they have very big difficulties actually telling anyone what the real differences are if you don't allow them to use the word positivist and natural law. So by now, I would think that I personally have the very radical opinion of saying that at best, just prohibit students from ever using any of these terms that refer to any of these boxes. And I think this is why I so much like John Tasioulas' introduction, because there is this divide between positive and natural law that I think, even though it is philosophically incredibly interesting, has done very little for the students of jurisprudence. But of course, I can only say that because I've never taught it myself, and I know this is horribly difficult. So maybe I'll have to change this all once I actually get to teaching it, if that ever happens. But I think, yeah, admitting that one will have to fail is the only viable option in this regard, as unfortunate as that answer is.
So I'd like to try to get to 2 more questions. One is a question for Christoph from John Tasioulas, who asks, as a stalwart of jurisprudence at King's, what has given you most satisfaction as a teacher of the subject, and how would you respond to claims that jurisprudence should be optional?
Yes. So I'm just checking if I'm unmuted. So I'm not a stalwart. I'm as stalwart, yes. So I'm contributing, and I love to contribute that. The most satisfaction has been when I felt that I've overcome the difficulties. I think that Lawrence perfectly described, and John too. I think that I fully agree with you, Lawrence. I think and you put it very well. If students can just put people quickly in boxes in order to pass the exam, then it's frustrating. And it's of course deeply satisfying if a student or a couple of students manage to produce insightful pieces, and you think as a teacher that you have helped them to do that. So it's this kind of midwifery that you help students hopefully to give birth to their own ideas, and that is indeed the most satisfactory thing. So let me just finish this question. I do think, and just to push back a bit against your and John's point, I do think that it starts off with, you have to start off somewhere. And you might start off with just putting people in boxes, and then you starting with these boxes, with these very, very abstract concepts, you then start to refine them. The danger is, of course, I fully see that, is that you end where you start, and that's considered the end of it. But I can't see how you could start otherwise. I can't see how you could start, with all the without ever introducing anything like that. I think that something would be amiss too, but I'm open for debate. And to finish off, how would I respond to people claiming that jurisprudence should be optional? Well, I think what we just heard today would be a great argument. I think, and what I hear from students, to be honest, I mean, a lot of students start off by saying, I don't know why I have to do this, and at the end, most students like it. They need to be, they just don't know what it is, and when they then do it, they love it. So I think we have to take leadership and ownership here, and should know what's in the best interest of students, and I think it is in the best interest of students to do jurisprudence, and that's why it should be compulsory.
So I'd like to do one last question to wrap up, and we have a question from an audience member. What do scholars working in legal theory think philosophers should spend more time looking into? And since this is the education panel, I'll rephrase this a little bit. What do students of law and jurisprudence wish that there was more philosophical attention to? Where do you think philosophers working in philosophy of law should turn their attention? What are the things that you feel maybe you would have a better grip of if there was more philosophical attention to it? And so maybe this goes back a little bit to some of the private law points. Maybe it goes to other thoughts that you have about sort of directions for the teaching of jurisprudence. Tasneem?
Well, one obvious one would be judicial review. So I think there's a lot of kind of deference theories and a lot on, the philosophy of law and judicial interpretation, but there's not enough on judicial review of something like delegated legislation, which is an innovative concept because it's a task that's normally the Parliament's, and it's delegated to the executive, but there's not a lot on that because that's a very niche area within law that's only expanded within the last 20-30 years. And I think it's particularly interesting. I'm fascinated by delegated legislation, and I think there's not enough on the theory behind, what justifies it, what constitutes a good interaction of Parliament, the courts and the executive in making good delegated legislation or regulations like we see with the coronavirus regulations. But yeah, that's my personal take on it because I enjoy admin law and public
law. Yewande or Lawrence, did either of you want to jump in on this?
I think the first thing that came to my mind was really the nature of obligation, because the first thing I studied during jurisprudence this year was the Hart and Austin debate. And one of the claims that I found that Hart made without really explaining it so much was just that he says there's a difference between being obliged and having an obligation. And I thought, well, you know, that sounds like it makes sense. But what really is the nature of an obligation? And I think that's the kind of question that really grounds the whole practice of law. If we claim that you have a legal obligation to do things, we need to know what an obligation really is. So I think that could be very interesting.
In a way, I'd really like to second that. I think that's definitely true. Maybe I should add, also very biased, and I'm afraid I'm portraying my Austrian bias in that regard. But I think two people who would be great to be covered in the jurisprudence, or actually who philosophers should, I think, take more seriously, and jurisprudence for that matter, are Kant, because there's a fascinating question of why this one person in the 18th century came up with the idea of separating the philosophy of right in this specific part of his moral philosophy. And then another, I think, author who is unfortunately very neglected in the whole Anglophone world, so to my knowledge, at least in the US, completely neglected, is Hans Kelsen, which is also very unfortunate. And both of these authors, I think, have a whole lot to offer for addressing precisely that question. And I don't quite understand why so far. Christoph.
Sorry, I just wanted to go ahead. I just wanted to point to John. Go ahead.
Oh, no, I was just about to say, I've never so far understood why both authors are so, well, so much neglected in both the UK and the United States. I know they sound obscure and there's, you know, they're somewhat infamous in some ways, but I think there's a whole lot of great philosophy in there that jurisprudence would, I think, benefit from. And maybe this brings us back to philosophy of private law, right? I think there's a good reason why so many people interested in private law are also so much interested in the philosophy of Kant and the doctrine of right. But I'll stop there.
Can I just say, Yolanda, thanks for what you just said. I mean, your contribution was really just classic jurisprudence obligation. That's the core, one of the core topics of hardcore classic jurisprudence, which I very much like. And Lawrence, two things, of course, in self-advertisement. My last book is on Kelsen, an attempt to as an Austrian, of course, to make the work of Hans Kelsen more approachable to the Anglo-American, especially with the English and American context. So I recommend that to you.
All right. Well, I think with that, we'll wrap up this panel on those great insights into directions that jurisprudence might go. I'd like to really thank Yewande and Lawrence and Tasneem for being with us for this discussion of legal education at King's, and thanks to Christoph for the overview and context on legal education. And thanks to all of our participants for coming and hearing us talk about this, and for your excellent questions. So thank you.